Hello everybody, welcome back to my YouTube channel. My name is Rishabh and this is our revision lecture number 6 of the entire MCQ oriented fast track batch of CA Final SPOM Law, Corporate and Economic Law Set A. In this video we are going to cover your SEBI Act and SEBI LODR Regulations 2015. So stay tuned till end of the video, and now without wasting much of time, let us begin. Before beginning, let me tell you, this entire PDF you can get in the Telegram channel, the link of which is given into the description. Please do join that channel, and also let me know in the comment sections how you like the video, how did you like the notes, because this is an immense pleasure for me to understand the requirement of the audience, and it will help me to boost up my confidence, and it inspires me to bring up more such content. So now let us start with the chapter of your SEBI Act 1992. First we will cover SEBI Act and then we will move on to the SEBI LODR at the after completion of this chapter. Now, Securities and Exchange Board of India Act 1992. SEBI itself a body corporate having all the characteristics of a company, like it is having a perpetual succession, a common seal, and etc, etc. So all the basic the characteristics of a company are same as in case of SEBI, Securities and Exchange Board of India. Now the second point talks about the members of the board. Who will be the members of the Securities and Exchange Board of India? There would be a chairman who would be nominated by the central government. There would be 2 members from the Ministry of the Central Government. There will be 1 member from Reserve Bank of India and 5 members who would be nominated by central government, and out of those 5, at least 3 members should be whole-time members of the board. So this is basically the composition of the SEBI board. Point number 3 talks about central government has the right to terminate the services of the chairman and the 5 members. These 5 members who has been appointed by central government, the central government can terminate the services of these 5 members along with the chairman also, in what cases and what is the timeline. So these members and the chairman can be terminated by the central government by giving not less than 3 months of notice in writing. Matlab 3 months of notice in writing is to be given, or you may provide them with a salary of 3 months. That is the point number 2 talks about 3 months salary and allowances thereof. So central government, if it want, it can remove any chairman or any 5 members of the board by giving at least 3 months of notice in writing, or 3 months of salary in advance. They can give, and they can ask them to please terminate the organization. This is what the termination, and this MCQ was asked in my examination from this point. So again, from MCQ perspective, this becomes very important. Point number 4 talks about chairman and members appointed by the central government. The chairman and the members who has been appointed by the central government can themselves terminate by giving at least notice of 3 months. So minimum notice period is to be of 3 months, even if they themselves are terminating or they have been terminated by the central government. Point number 5 talks about the chairman ka tenure. So the maximum tenure would be of 5 years plus another term. He can be reappointed also. Members also can be members ke liye also the term is 5 years only. The maximum age is of 65 years for the chairman. So a person who has attained the age of 65 years cannot be appointed as a chairman. So again, MCQ can be framed from this also. Removal of members of the board. How a member can be removed? If he has been adjudged as an insolvent, declared unsound mind, he has been convicted by any offense, or he has usurped his position. In these cases, he can be removed from the membership of the board. Point number 7 talks about meeting of the board. Now the chairman shall be present. If chairman is not present in the meeting, then whoever is present, the members who are present into the meeting, they will themselves nominate one person who would be chairing the entire meeting. Point number 8 talks about any vacancy in the board shall not invalidate any of the act or proceedings of the board, such as defect in constitution of the board, defect in appointment of members or person. That means if a person has been appointed, for example, let me take an instance here, a chairman has been appointed who is more than 65 years. In such a case, any act done by that chairman who has been appointed will not invalidate any of the proceedings. That means there would be a defect, then until before the defect come to the knowledge of the board, the defect will be valid. Point number 9 talks about powers and functions of the SEBI. So I would recommend you to refer page number 1.6 of ICI module. Their power and functions are given. I don't see this is much of relevance from the exam perspective, but still, if you want, you can give it a glance. Point number 10 talks about general powers of the SEBI. What are the general powers that the Securities Exchange Board of India is having? They can suspend the trading of any security on recognized stock exchange. They can restrain any person from accessing securities market. They can suspend any office bearer thereof. They can freeze any bank account maximum of 90 days. These timelines are very important from your exam perspective, your MCQ perspective. So please be very careful with these kind of MCQs. So a bank account can be freezed for a maximum period of 90 days. Direct intermediary to not to transfer any kind of securities, and confiscate sale proceeds. Whatever sale proceeds they have obtained, the SEBI has the power to confiscate that. Point number 11 talks about, section number 11C talks about the investigation. So investigation ke liye what are the grounds under which the investigation can be initiated? So there is a violation of the act or transaction is prejudicial to the interest of the company. In these cases, investigation may be conducted again by the board against any company. Now powers that can be exercised with the prior approval of magistrate. Matlab these powers will definitely require the prior approval of magistrate, and investigation will not be initiated under these circumstances. They can enter with such assistance as may be required by the police assistance, such place as may be required, or seize books of accounts if they can be destroyed, mutilated or altered or etc. Matlab under investigation, an investigating officer can seize the books of accounts with the prior approval of the magistrate if he feels that the books of accounts can be destroyed, mutilated, altered or destroyed also. In these cases, books can be books can be seized, but again magistrate ka prior approval is required. He can enter with such assistance any place. He can enter with the prior approval of magistrate only. He can search any place with the prior approval of magistrate. This is what this talks about. Now the investigating authority may keep in its custody any book, registers, other documents and records for a period of 6 months. Whoever is conducting investigation against any company, then all the books of accounts can be kept, registers, other documents etc. can be kept for a maximum period of 6 months. Magistrate and judge shall not authorize seizure of books, registers, other documents and records of listed public company or any company who is in progress of listing, okay, unless such company is indulged in trading and market manipulation. So I told about 3 powers which are to be exercised only with the prior approval of magistrate, but these 3 powers cannot be exercised against a company who is a listed company or a company which is in the process of listing. But if the company which is listed company or any company which is in the process of listing, if they have been indulged in case of trading and market manipulation, then in such a case investigation can be conducted and all the 3 acts can be done with the prior approval of magistrate. This is what this point talks about. Now seize books of accounts, register etc. shall be returned for a period not later than conclusion of investigation. Okay, now seize and desist proceedings. Now what does the meaning of seize? Once the SEIZ, seize means you have confiscated the books of accounts with you. Seize, CEASE, this is again new term, and desist proceedings. So what does this mean? Seize order means stop and do not repeat. So when contravention is already conducted, then this order is passed. When does desist order is passed? It means contravention is likely to be conducted, and to prevent that contravention, a desist order is to be passed. In case of listed company in process of listing, these orders cannot be passed, can only be passed if offense is related to insider trading or market manipulation. In these cases only against a listed company or a company which is in the process of listing, seize or desist order can be passed. Penalty and adjudication, I would recommend you to refer. Okay, penalties is at the end of the chapter. At the end of this chapter, I have provided the entire tables from the ICA module, the penalties. You can go through those penalties once. Now, point number 14 talks about finance, accounts and audit. Now, all the grants, fees, etc., charges, whatever is received by the board, including any sum received by the SEBI, shall be credited to the SEBI general fund account. So, again, a MCQ can be from this also. These sums can be applied for salary, allowances and remuneration of the board, chairpersons, members, etc. and day-to-day activities के लिए भी this sum can be utilized. Now, what are the factors that determine the quantum of penalty? So, the penalty is given on the last part of this chapter, but what are the factors that will determine the penalty? It will determine by inappropriate gains to the defaulter, what is the amount of gain, what is the loss to the investor, and again, repetitive nature of the offense. If the offense is of much of repetitive, then the amount of penalty would be higher. Establishment, jurisdiction, composition of Securities Appellate Tribunal. An investigation has been conducted, report has been submitted to the board. Now, against the report that has been submitted by the board to the board by the investigating officer, can there be any kind of appeal mechanism is there or not? This is what something we are going to learn in this subsequent part. Point number 16 talks about Securities Appellate Tribunal. So who is the part of this particular tribunal? So a presiding officer, a judicial member, and a technical member. These three are part of your Securities Appellate Tribunal. Now onwards, I will call it as SAT. Point number B talks about jurisdiction of set by benches itself. So means different benches has been established by the SAT, where two or more JM, that is judicial member and the technical member, but at least one judicial member and one technical member should be there. That means a particular bench is established. In that bench there would be minimum of two or more judicial member or the technical member, but at least one of each. That means one judicial member and one of technical member should be there. Members, judicial member or technical member may be transferred from one branch to another bench. Qualification of PO means presiding officer, JM is judicial member, TM is technical member. Presiding officer का qualification is Supreme Court का judge, High Court, Chief Justice or High Court judge for at least 7 years he would have been there, High Court judge. Judicial member, High Court judge for at least 5 years. Tenure would be of 5 years, plus reappointment is available for a maximum period of 5 years. That means 2 terms of 5 years each can be there, and maximum age is of 70 years. Resignation or removal of PO, JM or TM. So they can resign by sending a notice to the central government. They can also continue to hold office until the expiry of 3 months from the date of receipt of the notice by the central government, until a person duly appointed as his successor enter upon his office, or until expiry of his terms of office. Now whichever is earlier, after which he has to be in the office. He has to continue with the office. Now point number 4 talks about defect in appointment or procedure of SAT should not invalidate the decision given by SAT. Any person who is at a senior position of IRDA, Pension Authority, SEBI in last 2 years cannot be appointed as a member of SAT. Point number H talks about filing of vacancy. Vacancy can be temporary or permanent. In case of permanent vacancy, JM or TM, it shall be filed by the central government itself. So JM or TM ka vacancy, it's to be filed by the central government, but in case of PO, presiding officer, it shall be filed by the central government until that senior PO will be of the senior most. Till then, he would be the person to appoint that. Point number 17 talks about central government may supersede SEBI. There are circumstances in which central government may supersede SEBI. Means central government go beyond to the powers of SEBI. There is a grave emergency requirement. SEBI is not complying with the direction of the central government. SEBI is not complying with this particular act. SEBI Act 1992 mein SEBI is not complying with this act, or there is a public interest required in for which the SEBI central government has to intervene. In those circumstances, central government may supersede SEBI. Point number 18 talks about appeal to SAT. Who can make an appeal to the Securities Appellate Tribunal? As person who is aggrieved by the order of the board, any person who is aggrieved by the order of adjudicating officer, or aggrieved by the order of IRDA, Pension Fund or Development Authority, they can make an appeal to the SAT within 45 days plus sufficient cause is available, then an extension of further 45 days is available. So that means an appeal can be made by any of these 3 persons within 45 days plus 45 days ka extension can be granted if there is a sufficient cause. This is what it talks about. SAT can either confirm, modify or set aside the order. The appeal filed with SAT should be disposed expeditiously within 6 months from the date of receipt of appeal. So the maximum time period up to which the appeal is to be disposed of is 6 months. Appellant may authorize one or more CA, CS, CMA or legal practitioner or any officer to represent him before the Securities Appellate Tribunal. Appellant means the person who is making an appeal. No civil court shall have jurisdiction with respect to suits, proceedings, legal proceedings in respect of any matter which an adjudicating officer or SAT under this act is having concern. Point number 19 talks about appeal to Supreme Court. Who can make an appeal to the Supreme Court? So there was an order passed by adjudicating officer board. We went to the Securities Appellate Tribunal within 45 days. Now against the order of SAT we can go directly to the Supreme Court within 60 days plus additional 60 days can be granted if there is a sufficient cause. What are the miscellaneous provisions in this chapter? All the members, officers of the board are public servants. No legal suit proceedings or prosecution shall lie against the central government or any of the officer of the board for anything which is done in good faith. Any person contravenes the provisions of this act, then imprisonment may be of up to 10 years or fine up to 25 crore, whichever or both can be granted to such a person. No court shall take cognizance of any offence which is punishable under this act. Special courts may be established for speedy trial. That means special courts can be established for the speedy trial of these kind of offences, for the cognizance of the offences. Composition, there would be a single judge who would be appointed by the central government with concurrence of Chief Justice of High Court. All the offences under this act shall be taken cognizance and trial before the special court. Now point number 21 talks about the recovery of amount. If a person fails to pay the penalty imposed under this act, then recovery officer may recover from such person by way of attaching and selling of the immovable property of such a person, attachment of person's bank account, detention of the person in prison, or maybe appoint any receiver of person's movable and immovable property. So by these means the amount of penalty can be recovered by the board, by the adjudicating officer. When a person dies and his or her legal representative are there, and the person who died, the person's estate is not sufficient for the legal hire to discharge, then in such a case the legal hire would be personally liable for any kind of shortfall in the liability. Okay, that's about your SEBI Act, and these are basically the summary of your entire sections of entire penalty sections. I would recommend you to please go ahead with all these. These are 3 pages, penalties given over here. Please go ahead with that, and that's all about in your SEBI Act. Now let us start with SEBI LODR regulations 2015. Now before starting with this, let me tell you, in the first video of this entire series, I had covered SEBI ICDR. Issuance of capital and disclosure requirement regulations I had discussed in that particular chapter. So you can refer that chapter after that revision video, the link of which I will be also given into the I button, so please check out there also. And this is, you have to do that chapter ICDR you have to do after completing your LODR requirement, or you can do earlier before also. Now before starting with this particular chapter, let us understand the entire sequence. There would be a company which would be a listed company, alright? But when a company is going to list its securities on the stock exchanges, then he has to, that company has to follow ICDR requirement, that is issuance of capital and disclosure requirement. While at the company is in the stage of listing, then company has to comply with the ICDR requirements. Once a company has complied with the ICDR requirement, the company will become a listed company. After the company becomes a listed company, the company will have to mandatorily comply with LODR requirement. LODR stands for listing obligation and disclosure requirements, and this is basically to ensure an effective corporate governance into the organization. What does a corporate governance consist of? It consists of fairness, accountability, and transparency. Transparency is with respect to appropriate disclosures, which would be monthly, quarterly, yearly, or even daily basis. Now, applicability of LODR. To whom LODR is applicable? LODR is applicable to all the companies which is listed on main board, basically your NSE or BSE stock exchanges. Any company which is listed on SME exchange, small and medium enterprises, we are saying nowadays a lot of SME IPOs are coming. So those IPOs, whatever platform they are listing, those platforms or those IPOs, those companies are also covered under the LODR requirement. And innovators growth platform, this is basically a platform wherein a private company can list its securities such as debt instruments, etc. So for those kind of companies also LODR requirement is mandatory. That means even if a private company having any of its securities listed on any of the stock exchanges, including IGP innovators growth platform, then in such a case that private company is also required to comply with SEBI LODR requirement. Now, securities to which LODR is applicable. Here we studied about what are the companies to which LODR is applicable. Here we are going to understand what are the securities to which LODR is applicable. It is applicable for non-convertible debentures, NCDs, Indian depository receipts, securitized debt instruments. Securitized debt instruments, basically a securitization ka process that you study in your AFM, that basically those securities instruments, security receipts, units of mutual funds, or any other securities as prescribed by the board. So these are the securities to which the requirement of SEBI LODR is applicable. Now what are the provisions related to corporate governance? So firstly, there is a composition of board of directors. There should be minimum 50% non-executive directors plus at least one woman director should be there in the organization, in the company which is listed on any of these 3 platforms. Okay, now top 1000 listed companies based on the market capitalization, they shall have at least one woman director who shall be independent director. Here we studied there should be minimum one woman director, but the next proviso says that top 1000 listed companies shall mandatorily have at least one woman director, which should also be an independent director. Alright. Now point number 2 talks about number of independent directors. Where the chairperson is the non-executive director, then in such a case minimum 1/3 should be your independent directors. Where the chairperson is executive director, please make the full form of these words, because in order to understand the space I have mentioned the short form, so please make these write the full form of these words. NED stands for non-executive director, ED stands for executive director, and there should be minimum half of the directors where the chairperson, half of the directors should be independent directors where the chairperson is the executive director. Now, where chairperson is non-executive director, along with that, he is also the promoter, he is related to the promoter, he holds the management position, or he is one level below the board of directors, then the minimum half of the board shall consist of independent director. So this is basically your proviso or your provisions with respect to independent director. Now, where promoter is a listed entity or an unlisted entity. Now, a promoter is a listed entity. Okay, and its director, promoter or nominees except independent directors. So in this director word, where the company is a listed entity, so please change this word. This is an entity. The word should be entity. Where the entity is a listed entity or unlisted entity, then in case of listed entity, its directors, promoters along with the nominee directors except independent directors. So here the word is except, and here no word except word is missing. So these are deemed to be relative in the both the cases, director, promoter and nominee director, but in case of listed entity, independent directors are excluded. Point number 5 talks about no requirement to have independent director in case of section 8 companies. That means section 8 companies are exempt from having any independent directors. Section 8 companies which are listed on any of the stock exchanges are exempt from having any independent director. Now, board of directors of top 2000 listed companies, there should be minimum 6 directors and the maximum age should be of 75 years. Quorum in case of top 2000 listed companies would be 1/3 of the 1/3 or 3 directors, whichever is higher, plus one independent director. So here the word is or. Please change this word. Here the word is or. This should be 1/3 or 3 directors, whichever is higher, plus one independent director should also be required into the meeting in order to have appropriate quorum. Point number 4 talks about board meeting. Now the board of directors shall meet at least 4 times in a year, and the gap between the 2 meetings shall not be more than 120 days. This is same as we have studied in section 173 of Companies Act. Point number 5 talks about what is the maximum number of directorships. So a director can be maximum membership he can hold in any committees can be of 10 committees. So he can have membership in maximum 10 committees. A director can be chairperson of maximum 5 committees, and companies to be included and excluded while counting these committees. So all the public companies are to be included, and private companies, foreign company, high value debt listed company and the section 8 companies are to be excluded from the counting of this committee limit. Alright. Now for determination of limits, only audit committee and the stakeholders relationship committee is to be counted. So what we understand is what are the companies that needs to be included while counting the committees, and in the next point, this point we have studied what are the committees that needs to be included while counting the limits. So the committees would be only nomination and remuneration committee and the audit committee the committees that you have to count is only the audit committee and the stakeholders relationship committee. Point number 6 talks about corporate governance for subsidiary of listed company. This is a listed company. The subsidiary of listed company is also subsidiary is there. Then what are the requirement? What are the corporate governance requirement for that listed company also? Now point number 1 talks about at least one independent director on the board of listed company shall be director on board of unlisted material subsidiary. Matlab, one independent director on the board of listed entities shall be the director on the board of unlisted material subsidiary. So what does the word unlisted material subsidiary means? It means the income or net worth of such a subsidiary, income or net worth is more than 20% of the consolidated income or net worth of the listed company and the subsidiary company in the preceding accounting year. That means the amount of net worth or the income that we generate from that particular unlisted company should be more than 20% of the consolidated income or the net worth respectively. Then such a company would be called as material subsidiary company. The board meeting minutes of unlisted subsidiary company are to be placed before the board meeting of the board of directors of the listed entity. The management of subsidiary shall bring to the notice of board of directors of the listed entity a statement of significant transactions or arrangement that exceeds 10% of the total revenue or expense or assets or liability of unlisted subsidiary company in the preceding accounting year. A listed entity shall not dispose share in unlisted subsidiary company, resulting in reduction of shareholding to less than or equal to 50%. Or cessation of control without passing special resolution into the general meeting. That means if a company is willing to reduce the shareholding in an unlisted subsidiary, material subsidiary, then in such a case, if the reduction is leading to shareholding of less than or equal to 50%, then the company is mandatorily required, the listed entity, the entity is required to pass a special resolution into the meeting. But special resolution is not required if this is as a result of scheme which is duly approved by the tribunal or the court, and along with that, and such an event is disclosed to the recognized stock exchange within 1 day of the resolution plan being approved. Then in such a case, SR is not required. Now selling, disposing, leasing of more than 20% of the asset, then again SR is to be passed, but again SR is not required under these two circumstances. That means these two conditions are to be mandatorily fulfilled. Okay. Okay, now let us move on. Compliance report on corporate governance. Now, when are we required to file compliance reports? Now, quarterly compliance report is to be filed within 15 days from the end of the quarter. Annual compliance report is to be filed within 6 months from the end of the financial year, or it can also be filed along with the quarterly report of the second quarter of the next year. This is what the point number 7 talks about. Point number 8 talks about related party transactions. So what are the related parties under this particular act? So any person, entity forming part of the promoter group of the listed entity, or any person, entity holding equity share or of 20% or more or 10% or more from 1/4/2023 are to be considered as related parties, and this is not applicable in case of units issued by the mutual fund. Following transactions shall not be a related party transaction. If you give it a read, you will be able to understand it easily. Alright. Now, what are the material related party transactions? Transactions that exceed 1000 crore rupees or 10% of the consolidated turnover, whichever is lower, are the material related party transactions. So these are very, very important from your MCQ perspective. So please be very careful with these kind of limits. All the related party transactions requires prior approval of the audit committee. Only independent directors of the audit committee can approve such a related party transaction. Now we are going to study omnibus approval. That means instead of asking approval for related party transactions every time, there can be an omnibus approval which is to be provided by the audit committee, which would be valid for a period of 1 year, and the maximum amount of transactions that is permissible under omnibus approval in aggregate total amount would be 1 crore. So this is what talks about omnibus approval, which would be provided so that in each time where there is a related party transaction, so there is no need of having approval from the audit committee. This is valid for maximum of 1 year and maximum amount of 1 crore only. So that means from a related party, maximum amount of 1 crore can be undertaken under your omnibus approval. Now the committee is to be constituted. What are the committees under your LODR? It's a listing obligation and disclosure requirement. So there is nomination and remuneration, there is audit committee, there is a stakeholders relationship committee, there is also your risk management committee. All these committees ka the entire crux is given onto the next pages. So please go through those. Quarterly compliances, along with the yearly compliances, what are the compliances that you have to go? We are going to study in the next pages. Prior intimation to the recognized stock exchange. So in order to, if you are if a company is undertaking any kind of transactions, then it has to prior intimate to the recognized stock exchange before initiating the transaction that we are going to study in the next part. Now this is the summary of all the committees. So there is audit committee, there is nomination and remuneration committee, there is also your stakeholdership relationship committee, and there is risk management committee. So I would recommend you to please go through all these committees, and then MCQs are being asked from these committees. So please be very careful. All these limits, number of independent directors, requirement, and etc. etc. Now annual compliances. So what are the annual compliances? So this is within 60 days. You have to submit audited standalone financial statements from the end of the financial year. So if you give it a read, you will be easily able to understand it. Even if I read it, it would be a waste of time. So I would recommend you to please go through these on your own, and you will be able to easily remember it. Now the quarterly compliances, again the same thing. You have to go through these and you will be able to understand it. Now here there is a, I would say there is a important points that needs to be undertaken. Somewhere here it is given 2 working days, somewhere it is given only 5 days, again here it is given 5 working days, 11 working days. So please be very careful with respect to working days. Working days includes your excludes your Saturday, Sundays and public holidays. So that means those days are to be excluded while initiating these kind of transactions. And apart from that, you have to exclude the date of intimation and the date of meeting. So the date of meeting and the date of intimation, the gap should be actually 2 working days, or maybe 5 working days, 7 working days, or 11 working days, as the case may be. Only in one case it is 5 days, except all the other places it is working days only. So I would recommend, please go through all these and you will be able to easily remember all these things. I think that's all about in this particular video. If you like the video, please share it with all the friends, and do let me know in the comment section if you like the video. Please share it all the friends. Thanks a lot for watching. Thank you so much.